Good evening, good morning to all subscribers and viewers of California Tamil TV. This live chat with immigration expert Srividya Krishnamurthy is brought to you by Aaapakadai and Realtor Lakshmi. We are very thankful for your support. Given the more general applicability of the questions and the answers in this session, the entire session is going to be in English, so everybody can follow along. Joining us today is attorney Srividya Krishnamurthy, who's been an immigration attorney for over 15 years. She was born in Chennai, India, and moved to the USA in 1998. Srividya ma'am, over to you. Short introduction, please.
All right. Thank you for having me. I've been an attorney for over 15 years, practicing immigration law. I've worked with law firms in New York. I am licensed to practice in New York and Texas. And I have had my own practice for over 10 years. I am currently practicing immigration in California, in the Bay Area. I specialize mostly in business immigration, but also do other visas like spouse visas and green cards for parents, citizenship, anything related to that. And I'd also like to remind everyone that we're just here to have a general discussion. Anything that I state cannot be taken as legal advice. There's no attorney-client privilege that governs our conversation here. So please remember that and do not give me any case details. I cannot answer any specific case-related questions because of that. If you have case-related questions, I would advise you to get a consultation with your own attorney.
Thank you, Srividya. That was awesome. And again, thank you so much for spending this time with us, because this is time of uncertainty, and I'm pretty sure everybody that's tuned in and everybody that's going to be watching this video later, they're really going to appreciate a lot of these questions and answers. We have already received a lot of questions on the link that we shared yesterday. So we do have a pipeline of questions. And for anybody that's tuning in right now, feel free to post your questions in the YouTube comments section. And we have a team of people on the back end compiling all these questions together so we can get it in front of Srividya here. So let's get this party started. The first question we have is actually from Karthik Vasudevan. He thanks us all for doing this. So yes, we want to thank all the sponsors and Srividya, for you also for taking this time out. The question is, if legal permanent resident aliens receive the CARES Act stimulus check, will it be considered public charge? And he sent us a two-part question. Later, during naturalization, will this be a problem? Like inadmissibility under public charge rule and such.
Okay. Yeah, that's a good question. And USCIS has put out a notice stating specifically that any aid related to COVID-19 will not be considered public charge by them. So the stimulus checks are okay. And also related to that, if you receive any test, the COVID-19 test itself, that is paid for by the state, that is also not considered as receiving state aid for the purpose of public charge.
Thank you so much for answering that, Karthik. We hope that answers your question. Feel free to, if you do have any follow-up, and I hope you're watching right now, feel free to post a question ahead. The next question we have is actually from Chinna Armugam. Chinna's parents have been here since January 30th, and their I-94 date is actually July 29th. So they have return tickets for July 26th, but given the current situation, he's asking if he can actually extend their stay, and by what date does he have to apply to avoid any issues?
Yes, you can extend. You will have to file an I-539 to extend their status within the U.S. You have until their I-94 expiry date to file that. So you don't have to do it right away. You can wait to see if the situation improves, if they want to leave. And by May or June, if you think it's not going to improve and they still want to stay here, you can certainly go ahead and file for their extension.
Okay, we really hope the situation improves, Chinna, and hope your parents actually make it back safe and sound. Thanks for that response, Srividya. Moving on to the next question, we have a question from Siddhant Sahu. Visa stamp expires in June, but I-79 status, 797 status is good till June 2021. So does he just need to get a visa stamp to re-enter US, or would you recommend waiting until the US embassy in India actually opens?
Okay. Can you give me those dates again? The I-797?
Yes. So I believe the way he's actually stated it is the visa stamp, his current stamp expires in June, but the I-797 status is good till June 2021.
Okay.
So he's asking if he needs to get a visa stamp to re-enter US, or would you recommend waiting until the US embassy in India actually opens?
Okay. So your visa stamp in your passport is only if you wish to travel outside the country and re-enter. As long as you're planning to stay within the US, your I-797 is sufficient for whatever status you are in. So without knowing more information, I can get more specific, but the visa is only for traveling. So if he's intending to continue to work here based on the I-797, assuming this is not related to a work visa, he can continue to do so. He does not need to get a new stamp just to stay here.
Thanks for that answer, Siddhant. We hope that answered your question. The next question we have is from Vignesh KB. Thank you for sending the question in. So Vignesh says that he's actually on an H-1B visa, and due to COVID-19, his plant was shut down temporarily. So his employers are asking him to take a furlough and file for unemployment benefits. They do know that he's on H-1B, so he's asking if he can file for benefits. And also, just to add, this has been a common theme of questions that we've gotten from other sources as well. So we'll feel free to add more information if you will.
Okay, sure. So I have encountered this in the last couple of weeks. Unfortunately, there are a lot of employers furloughing employees on H-1B. One of the principles of the H-1B regulations is that employers cannot bench H-1B workers. And furloughing is pretty related to benching, which is just there is no work for them. Mm-hmm. So there is no furloughing of H-1B workers. You're either working, and if they're not paying you, that means you're no longer in H-1B status. Okay, so it is important to understand that distinction. You cannot just say I am furloughed. Once you stop receiving a paycheck and your employer doesn't employ you, doesn't have productive work for you to do anymore, you lose that status. And the other thing is that unfortunately H-1B, L-1 workers are not eligible for unemployment benefits, because once you lose your H-1B or L-1 status, you're no longer available to work. You need sponsorship of another employer to work. And most states require, I mean, this varies from state to state, but this is a general requirement of most states, including California, that you have to be available to work immediately when you file for unemployment benefits. And that is not possible when you're on an H-1 or an L-1. You need an employer to sponsor you. And therefore, most H-1, L-1, pretty much, well, those on H-1 and L-1 visas cannot apply for unemployment benefits.
That was very, very helpful. We really are hoping that the situation gets better for everybody. I actually do have a follow-up question. So it's interesting you mentioned the L1 status as well. Actually, one of my friends, Sandeep, had this question. So he's actually on an L1 visa, and they got a notice that at the start of April, they're actually going to stop receiving a paycheck, but they're still continuing to work. So how does that fall into this range of explanation that you just gave us? Does it mean that he's still in status and he can continue to work but receive a paycheck later, or how does that work?
I mean, employers are trying to do their best. I understand that, but the regulations require that they need to keep these employees on payroll and they have to pay them. So that is something he will have to take up with his employer. Because he might be considered out of status if he's working without being paid.
Got it. Thank you. Thank you so much for that. And the other follow-up question.
Yeah. Sorry.
Go ahead.
As a follow-up to the unemployment part of it, I just wanted to add one more thing, that if you have a spouse on an H-4 EAD or an L-2 EAD, they are eligible to file for unemployment benefits because the EAD card allows them to be available for work immediately. So that is something they can consider. But the actual H-1B worker or the L-1 worker himself or herself cannot file for unemployment benefits, but someone on an EAD can.
That is actually super helpful, and I'm pretty sure it's going to help a lot of people, that specific comment there. The other follow-up question I had to that was based on what you were just telling us. So let's say the people are starting to get furloughed, or people stop getting a paycheck on, say, the 15th of April, right? Mm-hmm. Does that mean that they're out of status immediately, or is there a buffer time for which they are still in status, and they can that they can hope that things are going to get better during that time?
Okay. So this is specific to an H-1B situation. We'll talk about L-1s later. The okay. H-1B worker does go out of status right away, mm-hmm. but USCIS does provide you with a 60-day grace period within which you can try and find another employer and file an H-1B transfer. So the regulation actually is 60-day or the expiry of your I-94, whichever is earlier. Okay. So you have to remember, if your I-94 expires before that 60-day period, you have to go by the I-94 expiry date, or else it's 60 days within which you can file and find another employer and file your H-1B transfer, or you use that time to wrap up your affairs here and plan to leave or file for a change of status to another visa.
Thank you so much. We actually have another question coming from Karthik Kumar. Karthik is on a STEM OPT extension, and it expires on the 7th of July 2020. His H-1B was filed last year, and it got approved, but mm-hmm. it was approved with consular processing. Now, given the condition, can we actually extend past July 7th? That is the question he has.
Okay. So someone on a STEM OPT normally also has a 60-day grace period mm-hmm. After the expiry of that STEM OPT, which is on their EAD card. Mm-hmm. So they can use that grace period to kind of see if things improve before he can go and get his visa stamped. But if not, he would have to leave, or he'll have to file a change of status to another status, or he can also file to change his status from F1 to H1B based on that H1B approval. But it's like filing, his employer will have to file another H1 petition seeking change of status, this time instead of consular processing.
Got it. Thank you for that, Karthik. Hope that helps your situation. And again, if you have a follow-up, feel free to post in the comments. Now, just going back to another general range of questions that I've heard, actually, this is one of my friends sent me this question. So he works for a small startup, and he just got promoted. So there's a pretty big jump in the job title, and his H-1B is going through amendment for that, while they're responding to an RFE on it, right? At this time, what their employer has also announced is that they're going to be part-time. All the H-1B, all the workers in the company are going to be part-time for 50% of the time. And so they're only going to work 20 hours. So he has the question that, is it okay if there's part-time in H-1B, and is 20 hours okay, 20 hours of work okay? And his follow-up question was, can he actually continue responding to the amendment? Also, should they let USCIS know about the part-time amendment or a part-time status, or should they file another amendment for it?
So that's a good question, because a lot of I've heard some employers doing this. If your H-1B work is cutting you down to part-time, your employer has to file an amendment with USCIS. Letting them know that they're converting you from a full-time employee to a part-time employee. And then once that petition has been filed with USCIS, you can switch to part-time employment, and 20 hours is fine. But that amendment has to be filed.
So that has to be a separate amendment and not not in response to the RFE. Is that right?
Correct.
Perfect. Okay, that was super helpful. Uh, we have another question from Magesh Somasundaram. Thank you for sending this question over, Magesh. So what he's asking is, if he loses his job, so he's stating that the grace period of 60 days or any additional, are there any additional days related to COVID-19? Because recent pay stubs are needed for H1 job transfer, and because he won't have a pay stub during the unemployment grace period, will that actually matter?
So right as of now, USCIS has not extended any deadlines or any existing timelines. So he would only have that 60-day grace period time. And as long as you are using that, and you can use that 60-day grace period only once with each employer. So if he is using that, then of course they will have to put that in the letter somewhere, let USCIS know somewhere that he's using that, and they will not be expecting to see a pay stub for that 60-day period. It's 60 days from the last pay stub that he received from his current employer.
Okay, that was super helpful. And we have a follow-up question from Siddhant Sahu, where he was asking about the expiry of the 797 date being 2021 and his stamp expiring currently, right? So a follow-up question is, if he were to travel outside the US to India, given that the US embassy in India is closed, are there any other alternate options for him to get a stamp before re-entering?
No, if he travels, then he will have to wait. Pretty much all consulates and embassies are currently closed for visa services all around the world. Mm-hmm. And until the situation improves, they won't open. And even when they do open, I expect to see long wait times before you can get visa appointments.
Got it. So, thank you so much. That I'm pretty sure that would help Siddhant as well. Anything you wanted to add there, Srividya? I didn't mean to cut you off.
Oh, no. So, yeah, I was just going to say, if he does travel to India, he may find himself stuck there. He'll definitely need a valid visa to re-enter.
Okay. Super helpful. And we have the next question from Deepak Babu. Again, thank you for sharing the question here, Deepak. So Deepak's parents are here with him on a B2 tourist visa, and the I-94 is actually expiring the first week of June. So he's asking if he needs to file a separate extension or any special case with COVID-19, so they're not out of status.
No, he should go ahead and file an I-539 for them to extend their B1, B2 beyond that date. People who are here on, I'm just giving you a related piece of information, people who are here on an ESTA visa from Europe or a visa waiver program that that the US has with certain countries, they are allowed to enter here for 90 days. And those people can actually contact their local CBP office and get a 30-day extension. It's called satisfactory departure. CBP is doing that for those here on an ESTA or a visa waiver program. But for those on B1 and B2, you have to file the I-539 with USCIS to request an extension. I would suggest that they add a letter along with the extension explaining the reason why they're not unable to leave. Especially in the case of India, they've closed the border and they're not allowing any flights in, so they can mention that as a reason. And I would also suggest that they leave as soon as possible once everything normalizes, and not actually wait for a decision, because a decision from USCIS may take a long time. But it's probably once you file the extension and they get the receipt notice, but they should leave as soon as they can.
Absolutely. Thank you for answering that, Srividya. So just for everybody that's tuning in right now, this is a live chat with our immigration expert, Srividya Krishnamurthy. And if you're tuning in right now and you have any questions about immigration and the uncertain times of COVID-19, feel free to post in the YouTube comment section. We have a team working in the back end sending us the questions live. So feel free to ask away and we'll try and get as many answered as possible within this session. The next question we have is actually from Parthiban Subramaniam. Thanks, Parthiban, for sending this over. He's asking something about the furlough, so I'm just going to read the question. We might have answered it, so I'm just going to make sure. So he says employers furloughing for 30 days for anybody who's on an H-1B and start paying in full after that. Then could they consider that the H-1B employee was under the 60-day grace period, and is that okay? I don't believe we've answered that, so over to you, Srividya.
Right. So you could, in the sense that there is nothing that's stopping you from going back to work to the same employer within that 60-day period, as long as that employer has not revoked your H-1 once they laid you off. There is no furlough; it's considered a layoff, even though they're calling it a furlough. But after 30 days, if that employer wishes to hire you back and they have not revoked your H-1, you can. But you may not use that 60-day grace period again with the same employer at a future date.
That was super helpful, and hope he doesn't have to use it because we don't want more COVID-19 situations anyways. And we do actually have the next question from JC. He's in his 6th year of H-1B that's expiring at the end of May. The perm was applied during November 2019. And if he does receive an approved perm and apply for an I-140, can he actually extend to the 7th year H-1B with the I-140 receipt number?
Unfortunately, they have not said that they're allowing us to do that right now. I know there are quite a few people in that situation, especially with premium processing being suspended across all categories right now. So that is not available. There are certain questions that we have been sending USCIS and various scenarios that we are asking USCIS to consider. So far, they have not given us any information about this. Hopefully, they will let us do that. But if not, he may have to file for a change of status from H-1 to some other status and stay here while the I-140 is being processed, and try to, file an H-1 extension, file a change of status back to H-1 once the I-140 is approved.
Got it.
If it's not able to leave the country.
All right, gotcha. JC, hope that answers your question. And the next question we have is from Praveen. And Praveen says he's on his H-1B visa, and max out date is May 23rd. So his perm is still in progress, and with 140 premium processing suspended, he's not able to file for H-1 extension before the 6-year period expires. Seems like he's in the same situation as JC.
Same situation, yeah.
I hope, Praveen, I hope you're currently watching the stream, and hopefully Srividya's answered your existing question. The next question we have is from Visali, and what will happen to H-1B visa transfer to a new employer? The H-1B visa extension got extended sometime around March 15th, and she's given her extension documents to the new employer and did not get any information from the new employer about the employee transfer initiation details. So looks like she's in a situation where she's been left hanging by the new employer. So that's the question. Okay. So I guess the question is more broadly around what's going to happen to the visa transfer to the new employer, given all that.
Right. So USCIS service centers are still operating. So you can still file petitions with them. Local field offices and application service centers where you do biometrics appointments, those are all closed till May 3rd. But they're major field service centers where we generally file H-1 and related all petitions. Those are still open and functioning, and we are still filing petitions with them. So I would suggest she should check with her new employer to find out what's going on. They are not closed.
All right, that's great to know. Vishali, hope that answers your question. We have our next question from Modern Tamarachi. That's really cool. And the question is unused H-1B approved petition. So she has an unused H-1B approved petition on the 2008 H-1B cap. By any chance, can she use it right now? and right now she's on an L1B in the US.
Okay. So that question, I would say there's yes and no. It depends on which service center it's going to, and sometimes we have been able to recapture it, and sometimes no. I would suggest she gets, and there are reasons why. There are other questions that we'll have to ask to find out if she will be able to do that or not. I would suggest she contact an attorney with full details to find out if she'll be able to do it or not.
That was super helpful, hopefully. And the next question we actually have is from Sudesh. And thank you guys, for joining us and actually watching the stream and posting the questions. Keep them coming. We have our time with Srividya, who's giving us extremely amazing answers during these uncertain times. So keep the questions coming, y'all. So the next question we have is from Sudesh. And Sudesh says if he's not able to get the next 60-day grace period, he might lose the house he bought recently. We're very sorry about that. But he also apologizes for the irrelevant question. But he's asking, would it foreclose after he leaves to India? How does it work? Like, what happens if he loses the house? We hope that doesn't happen, Sudesh. But, for the legal part of it, I'll transfer it over to Srividya.
Okay. Yeah, unfortunately, that's not in my expertise. So I would suggest he should talk to someone that has expertise in that area of the field. But yeah, I'm sorry. I know these are very difficult times. I understand. We've been getting a lot of calls with various scenarios and questions, and we're also trying to navigate it along with you and trying to do our best for our clients. So, hopefully things will improve fast.
Yep. Hope situation gets better, Sudesh, and we hope nothing untoward happens. But as we say that, we're moving on to the next question from AK. With AK's spouse is working on an H-1B, can AK apply for an H-4 while still being on an H-1B during the grace period, during his or her grace period? Is it okay for that person to switch to H-4, or does it require him or her to travel to India to move from H-1 to H-4?
No, that's actually a great option. If both spouses are working on an H-1 and one of them is furloughed, they can certainly apply to change their status from H-1 to H-4. And that remains the same for anybody who's here with a spouse on a different status. Some of them have spouses on an F-1. And if you're on an H-1 and you're getting furloughed, you can certainly apply within the U.S. to change your status to an F-2 or an H-4 or an L-2 or any other status that's available to you as a spouse of that other visa holder. So.
Okay, that is definitely good to know. Hope that AK, that is super helpful. Hope it helps your situation. The next question we have is from Jansi Rani. Jansi's husband is on an H-1B and his extension got through in December 2019. But because of an error in the name on the application on the 797, they've applied for a name correction in January 2020 by the employer. So, but they've not heard back from USCIS yet and don't have a recent I-797, essentially. They don't have the amended one. How to know whether it's completed, or how to know, if not, how can they actually get this done faster? Is there a way to fast track this?
Yeah, these unfortunately name corrections and corrections on already approved petitions are not a priority for USCIS. It could take a while for them to give you the corrected petition, but that doesn't mean you're not in status. As long as you have a copy of the previous approval notice, you should still be fine, and he can still continue to work. It's just that the corrected approval notice may take some time to come.
Okay. That is again good news. That's good to know. And our next question is from Santosh. Santosh's office is in San Francisco, and they're closing at the end of May. So they have a law firm, Fragoman. I don't know if that's okay to mention, but they're working for the company, and they filed for the home address to be included in the LCA, and mentioned that they're going to be working from home permanently. So is that a problem? Because I've also heard this from quite a few people, given that we're all working from home now due to COVID-19. Is that an okay situation to be in, to be working from home permanently and so on?
Okay. So I don't know the full details of his situation, but I'll give you the what the regs say regarding working from home in a general scenario. Where, yes, most H1 workers are now working from home. As long as your home is within the same MSA, which is a metropolitan statistical area of the employer, or within commuting distance, which could generally be anywhere between 25 to 50 miles.
Okay.
All you have to do is post the LCA in your house for 10 business days, and you can work from home. That gets added to your public access file at the employer's site, and you can work from home. The other option, if you live far away from where your employer is, if it's not within the same MSA or not within commuting distance, there is a regulation called for short-term placement for 30 days. So you can claim your home to be a short-term placement site for up to 30 days and work from there. And if within 30 days, you do not go back to your regular employment site, at that point, your employer will have to file an H-1B amendment to include your home office as a work location.
Okay, perfect. That's great to know. Actually, I had that question myself, given I've been working from home for quite a while. So this is all good to know. The next question we have is from Sham. Sham says, what is going to happen to H-1B extensions? H-1 is expiring 31st August 2020, and the employer is yet to submit the petition to USCIS.
Okay. Well, I can't speak to his particular employer, but like I said, the service centers are open and all petitions can be filed. In general, an extension petition can be filed up to the day of expiry of your current petition. So as long as it reaches USCIS before his current petition expires, he'll be fine. He can continue to work based on the fact that the extension was filed, and he can work for 240 days if he doesn't get a decision before then.
That is great to know. Thank you so much, Srividya. And we also have another question for you from Dharani. So Dharani is asking, is it possible to file for a status change here in the US itself, though approval is for consular processing? Do you want me to repeat the question?
File for change of status? Yes. In general, yes. Or any change of status petition can be filed with USCIS here. I don't know if there's any particular status that she's looking at, or.
So I think the catch in her question was that the approval is for consular processing. So I believe.
Did she mention what is it to an H1 to what status? No. Okay.
Unfortunately,
but yes, not. Any change of status petition is still able to be filed with USCIS here because their service centers are still open. Yes.
That is awesome. That is good to know. Dharani, hopefully that answered your question. And the next question we actually have is from Dilip. And Dilip's friend is a US citizen and his wife is on a green card. That is a great situation. I wish I were in that situation, but no. And, she essentially went to India on the green card and she's gotten stuck there because of COVID-19. Will there be any exemption if she stays in India for more than 6 months this year?
Yes, whenever she comes back, I mean, the staying in India over 6 months will come up when she files for her naturalization. And I'm sure they will take into account the fact that there are no flights from India right now and she was stuck there. As long as you can explain that you had a reasonable excuse for your absence beyond 6 months, USCIS does take that into account.
Okay, that is good to know. Dilip, hopefully your friend's situation is great and hopefully that answers your question. Again, thank you guys for staying with us and sending us all these questions. We do have our next question from Monisha Shankar. And the question is, for extending travel visa, is USCIS accepting mail applications at this time? How long will it take for the receipt notice to come? And also, do we need to attach new tickets along with the application? I believe you've already answered this question in general, that the centers are all open.
Right.
But she had an added question on, do they need to attach the new tickets along with the application for travel visa extension?
It is, it's generally advisable to do that. Yes.
Okay, that is awesome. That is awesome. So I do have like a couple of other general questions that had come up. I mean, this is probably not related to COVID. This is more a generic, immigration question among a lot of people that I know here. So technically, and this is actually my situation as well, right? I actually have my I-140 approved, and I just moved jobs. I'm going through that process again, but I have my extension for the next 3 years. But my parents actually are here on a green card, and my sister is a citizen. So can I get any other parallel green card application filed either through the parents or the sister at any point, or is that not a possibility?
You can. Your sister, who's a citizen, can file a sibling petition for you, but the wait for that for Indians is also very long, probably just as long as your employment-based petition priority date. So I don't think that's
so
going
when you
to
say
process as much, but
yeah.
But yes,
so you're saying
always have 2 petitions going at the same time. It's not a problem.
Okay, yeah, I just need to go marry a citizen then. All right, cool. Sounds like a good plan. Okay, that is pretty awesome. I mean, if you know anybody, let me know. I'm kidding. But anyways, the other question that I've been hearing about in general from friend circle who have their parents here and so on. Parents are here on a U.S. visitor visa, and our visa 6-month stay is ending in May, early May, actually the 6th of May. Friends try to call USCIS, but they don't have any guidance on visa issues. So is there any U.S. immigration circular for such visa extension issues at all, or is this a problematic situation to be in?
So like I said before, most people who are going to be stuck here on a B1, B2 and unable to return home should go ahead and file an I-539 application with USCIS to extend their status here, and then leave as soon as the situation improves enough for them to go do so.
All right, that is actually pretty good. And I had like a bunch more generic questions, but before that, I'm gonna wait for a couple of seconds to see if we have anything else coming in the comments. We don't actually have anything else on the comments. So we are actually thinking we're going to wind up this session. We've been online for the last 40 minutes approximately, answering a lot of very complicated and interesting questions that our viewers have been sending us. I hope this was super helpful for everybody that is actually watching with us live, and for everybody that's actually going to watch this video after. And Srividya, thank you so much. Thank you so much for your time. And we really, really appreciate this, because a couple of things. I learned a lot during this conversation, and super helpful, because there's a lot of stuff that I potentially had questions that I never worried about, for God knows how long I've lived here. So this is a very enlightening session for me. And for all our viewers, this is Srividya Krishnamurthy again. Her website's actually www